Thanks, Judge.
Thank you, sir. Mr. Rojas, you got Terrence Currington, the sentencing. Terrence Currington.
Yes.
Good morning. Bond will be forfeited for non-appearance and reset at 100,000. If you can get in touch with them and get them here because it's an agreed probation, so I'll consider recalling that forfeiture if he shows up.
Thank you.
And is Mr. Rojas, you've got Terrence Currington. I understand he's
Okay, down the hall, Judge.
all right. I'll recall that bond forfeiture. All right, sir. You're Terrence Currington?
Good.
And so, Mr. Currington, you've been here before and in this court because you entered a plea, so you should have known where you were going, right?
Yes.
Okay. All right, Mr. Currington was previously in court and cause number 25 DCCR 1114, entered a plea of guilty to evading arrest or detention with the use of a vehicle. I've received the pre-sentence report. Have you both had an opportunity to review that report?
We have your own. Yes, Judge.
Any additions or corrections?
Not from the defense. No.
All right, sir, I'm going to find that you entered your plea of guilty freely and voluntarily. Find sufficient evidence to find you guilty. However, I'm going to follow the agreement that you made with the district attorney and defer all proceedings and place you on probation for 5 years. You're ordered to pay the $1,000 fine and to follow all of the rules and conditions of probation. If you do that, this is an excellent opportunity because you do not have a felony conviction on your record. And if you successfully complete the probation, then at the end, the case will actually be dismissed. You will never have a felony conviction. The other side of that, though, is if you violate any condition of probation, you can be brought back into court, found guilty of the offense, and sent to prison for up to 10 years. Do you understand? So it's my understanding that you have a THC card through the Texas Compassionate Use Program. Is that correct? Okay, so here's the thing. If you have that card, you can only use what they give you and the amounts that they give you. Right? So when you were caught here, you had a whole lot more of stuff that you weren't supposed to have. 2.6 ounces.
Thank you. That's not good. They didn't charge you with it, but they found some.
Inventory of the vehicle revealed a black backpack in the front seat containing 2 clear plastic bags of suspected marijuana totaling 2.605 ounces. That's not compassionate care stuff, is it? It is. That's how they give it to you in little plastic baggies?
No, that's she's asking for stuff.
I'm asking you.
Is that
What? Here's the thing. I'm sorry.
Using the bag. Plastic bag.
Is that how they give it to you?
Oh,
Okay.
you just put it in there
Why would you do that?
for the smell.
For the smell?
To block the smell? Right.
Well, if you've got a card, then why are you trying to block the smell?
I just don't want to be right now. Smell like.
Well, how about don't keep it in your car at all?
That too.
That too.
Yes.
So here's the thing. Having that card doesn't mean you just get to do whatever you want and be high and drive a vehicle. You shouldn't have it in your vehicle. You should use it for the purposes and the amounts and the times that they prescribe you to use it. If you're not doing that, then it's going to be a violation of your probation. So part of your probation order is that you cannot have it in a car ever. It is to be at your house, probably needs to be locked up depending on who else you live with, and it is to be used how it's supposed to be used. If there's any issue with that, then it's going to be a violation of your probation, whether you have the card or not. You understand? Okay. I'm handing you the trial court certification. It shows this was an agreement that I followed, and so you've waived your right to appeal. You need to have a seat here in the courtroom. Probation will call you up to their desk when they're ready to go over your paperwork. Mr. Kevin Lane?
Yes, Your Honor.
On Sean Dage is the sentencing. Good morning. Are you Sean Dage? And this is cause number 24 DCCR 2353. Mr. Dage was previously in court, entered a plea of guilty to evading arrest or detention with previous convictions. I've received the pre-sentence report. Has everyone had an opportunity to review that report?
Defense has your honor.
Yes, Judge.
Are there any additions or corrections?
None from defense.
No, that's that.
What? So I guess what I'm trying to figure out is the additional case. Was there an assault
Your honor,
filed also as part of this?
It was not filed, Judge.
it was refused, your honor, according to the report, and it's hotly contested on the defense.
Okay. Okay. So that's the burglary that was refused.
Yes, your honor. And I know there's a recitation of the facts but those are hotly contested.
Okay. All right. Well, then, I mean, obviously the criminal history gives me a whole lot of concern. And whatever went on that night shouldn't have happened. So. I mean, I don't understand. In 2019, there was an evading arrest or detention with previous convictions, and he got a 4-year TDC on it. So I guess.
The initial offer was for time in this case, Judge, after lengthy discussions with Mr. Lane and the fact that underlying case was refused. I came down with a probation. We respect your opinion on this.
My only brief retort, your honor, is these are evading on foot.
But you don't get to keep doing it and then get rewarded for continued bad behavior, right? You don't go to prison for something typically and then get a better deal the next time you do the same thing. You see how that doesn't make sense to me and to most people?
And your honor, brief argument, we are asking the court to follow the agreement. Mr. Daggs does have a lifestyle and a plan, work and paying child support, a life now that does not seem like anything that the court is reviewing now. The court does have the mechanism, of course, to really put them in jail for a long time. The more recognition therapy could work, any other type programs that court may have. We believe he can do it.
I mean, and so I guess the case is from 2024. Have you been out since then on bond? And I got the letter, and I'll take judicial notice. The court's file. It does include a letter that was sent over by your attorney from Mr. Peterson, who I used to work with and trust and value his opinion greatly. And he sent a very supportive letter about you working in that office building and that everyone valued you there. So obviously, maybe you finally figured it out because the criminal history doesn't look like it, but you're older now. A lot of this was when you were younger, but you got to realize that it doesn't matter if you get scared. It doesn't matter what you're doing. If a cop says they want to talk to you for any reason, you would have been talked to them and not been here in felony court if you hadn't ran, So being scared isn't an excuse anymore. Because if something happens, if I go follow this probation, and something happens while you're on this probation, you're looking at the 10-year sentence that you've already agreed to. No negotiations, 10 years in prison. Do you understand? All right, then I'm going to find that you entered your previous plea of guilty freely and voluntarily. Find sufficient evidence to find you guilty, and at this time, find you guilty of evading arrest or detention with previous convictions. Also find the prior offenses, convictions true that you pled true to. Sentence you in accordance with your agreement to a term of 10 years in prison, but I'm going to probate that. You'll be on probation for 10 years. The order to pay the
6 years, Judge. It's 10
so-
probated for 6.
Okay, sorry, the PSI has it as 10.
That's right.
So that would have been one of those corrections.
Yes. I
That I asked
apologize,
for.
Ron.
6 years probation. You're ordered to pay the $500 fine and to follow all of the rules and conditions of probation. It sounds like this shouldn't be a problem for you. It's just following the rules, go into probation, do your community service, keep working, and you should be fine. You'll be able to serve that 10-year sentence while you're out on probation. The other side of that, though, is if you violate any condition of probation, you'll be brought back into court and your probation can be revoked and you would be facing that 10-year sentence that you've agreed to. Do you understand? All right, I'm handing you the trial court certification that shows this was an agreement that I followed, and so you waived your right to appeal. I also handed you a written admonishment regarding your ineligibility to possess a firearm or ammunition. Because of the judgment entered against you, you're ineligible under Texas law to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. If you have any questions about the laws that make you ineligible to possess a firearm or ammunition, or about how long that lasts, you can talk with Mr. Lane. If you'll just have a seat here in the courtroom, watch for probation. She's going to call you up to her desk when she's ready to go over your paperwork. Good luck to you, sir.
Thank you.